Rise. The United States District Court for the Southern District of Iowa is now in session. Thank
Take a seat, please. Good afternoon.
Good afternoon, Your Honor.
Good afternoon. We are convened in the consolidated case, Grandstaff versus Heiner, Inman versus Howe. The motions to dismiss the third-party complaints. This proceeding will be video recorded, and the video may be posted on the website for the federal court system and this court's website. The parties to the case have agreed to allow cameras operated by court personnel to record the proceedings, so please limit noise or side conversations and other disturbances. I'm not sure what they mean by other disturbances, but that's what I'm supposed to say. Counsel, please assume that we have done our homework, so you don't need to tell us everything about the case. You can be as targeted as you want, although I suspect that an impending snowstorm will be as influential as anything on being targeted and to the point. We provided you with that Massachusetts St. Germain case. It was something that we came upon in the process of our work preparing for the matter, and we thought that it was obviously not controlling but interesting on the subject matter, so we wanted you to have a copy of that case. And also, the other issue is that it seems to me that there is also a fundamental question when we are dealing with the issue of what protection companies get in return for involvement in the workers' compensation system. And so the essential question of whether participating in that process and in return getting some protection from collateral attack is something that would be a protection against any collateral attack. So there's kind of that initial step, it seems to me, in the analysis that has to at least be considered, and so I'd be interested in any comments that you have in that regard. It would be the court's practice to go by the order in which the filings were made, which means the motion to dismiss the Howe-Langhoff third-party complaint would come first. Is that all right with you, counsel?
Yes, Your Honor.
And you can stay seated while you argue. That's fine with me.
Thank you, Your Honor. And I think with the filings yesterday afternoon, Heiner has dismissed all of their third-party claims against Hanifin, and Howe dismissed their claims arising from Grandstaff's action, and the only one which remains is the Inman action.
The parental consortium.
Yes,
issue,
sir.
Which is pretty much the direct issue that we've been kind of identifying here.
Yes, sir.
If I might.
Question?
Yeah, thank you. May it please the court. Slight correction. We intend to dismiss ours because we wanted to confer with counsel and didn't have an opportunity to about what form of dismissal we will use to dismiss the claim that Mr. Woodward referred to, but that'll be done within the next 7 days.
Yeah, that was my understanding of the pleading, that it would be done, and so that is our expectation. So, but we appreciate the information that there is that limitation as we proceed. Let's see, we also have, is it Ms. Weigel? Is Weigel the correct pronunciation?
Yes, it is Ms. Weigel.
All right, and can you hear us all right?
I sure can, Your Honor.
All right, fine. Well then, counsel, let me hear on the motion.
Thank you, Your Honor. On behalf of Hanifin Company, we have moved to dismiss the third-party complaints brought against it arising from the accident which occurred on September 13, 2011. As you indicated, the court's done its homework, so I won't go through all the facts, but I do want to point to a couple of the important facts. At the time, on September 13, 2011, the Howe semi-truck had broken down at mile marker 188 on Interstate 80. A call was placed to Hanifin Company to provide assistance. Hanifin dispatched 2 vehicles with 2 employees, Mr. Walsh and Mr. Inman. They were parked in front and in back of the Howe vehicle when the Heiner semi-truck approached, ran off the road, struck the vehicles, resulting in the death of Mr. Walsh and Mr. Inman. I don't believe there's any question that both Mr. Walsh and Mr. Inman were in the course of their employment and their duties arose out of their employment, which by its very nature implicates the Iowa Workers' Compensation Act. And that gets to the provisions of Section 8520, which I'll paraphrase, but it provides specifically that the rights and remedies under Chapter 85 shall be the exclusive and only rights and remedies of the employee, personal or legal representative, dependents, or next of kin against the employer. With a third-party claim, there must be common liability, and the Iowa Supreme Court has dealt with this for years. In the case of Iowa Power and Light Co. versus Ablid, ABILD, which is at 144 Northwest 2nd, 303, the court held prior to comparative fault that the employer was immune essentially from claims for contribution for injuries arising out of its employees. After comparative fault in Thompson versus Stearns, 345-131, the Iowa Supreme Court reaffirmed that position that the protections of 8520 precluded an action for contribution against the employer. I think both Heiner and Howe concede that to a point, but they're attempting to avoid the effect of 8520 through turning the question not as to the injuries sustained, but as to the damages which may be available. And I believe that misconstrues Section 8520 and its application to the present case. The Iowa Supreme Court has held that when we're dealing with Section 8520, it's really a question of subject matter jurisdiction. And that's Johnson versus Farmer, 537, Northwest 2nd at 770. It's a 1995 case. The court has said that the question is not what damages may or may not be available, but the question is whether the underlying injury is within the coverage of the Workers' Compensation Act. In subsequent case of Gansky, Ganske versus Spahn and Rose, 580 Northwest 2nd, 812, that's a 1998 case. The Iowa Supreme Court went on to quote Larson, where Larson states, if the injury itself comes within the coverage formula, an action for damages is barred, even though the particular elements of damage is not compensated for. What the third-party plaintiffs, and in particular on the Inman matter, are arguing is that because the claim is for adult consortium, that somehow it is outside the purview of Section 8520. They cite no authority for that proposition. And in fact, when you look at the specific the specific language of 8520, it provides that it applies not only to the employee, his personal and legal representative, but his next of kin. So on its face, that language is pretty clear. In Johnson versus Farmer, the case I cited earlier, the Iowa Supreme Court held that the exclusive remedy provision of Section 8520 precluded a claim for loss of consortium for a spouse and for a child, even though those are not directly compensated for under workers' compensation. Then we attached, it's an unpublished opinion of the Iowa Court of Appeals, but in the estate of Brehm versus Dubuque Community School District, 2012 Westlaw 4513858, the Court of Appeals, the Iowa Court of Appeals dealt with a very similar issue as what's raised here. In that case, adult children of Mr. Brehm, who was killed while an employee of the Dubuque Community School District, when he was backed over by a car, brought a lawsuit seeking loss of consortium. The adult children did. Again, they argued that because damages were not available to those children under the Iowa Workers' Compensation Act, that they were entitled to bring their case. The Court of Appeals specifically held that workers' compensation and exclusive remedy provisions of Section 8520 applied to the adult children's consortium claims, and again said you have to look at the nature of the underlying injury to determine whether or not workers' compensation, the exclusive remedy applies. And if it's an injury that arose out of in the course of employment, just as Mr. Inman and Mr. Walsh's injuries, or in this case death, did, then these claims, whether it's a direct action by the Inmans against the employer, or such as Heiner and Howe made in this case a third-party complaint, cannot stand because of the exclusive remedy provision that cannot be common liability to the plaintiff. And you had asked about other possible collateral type of attacks or claims against the employer, and I think, going through the cases, it's clear that where the nature of the claim arises from the injury, it's barred. Such things as the bad faith type of claims, those types of claims the court has said are outside of the workers' compensation realm, and therefore there is subject matter jurisdiction for the court, and those types of claims can be made. But in any type of claim which arises flowing from the injury, whether it's a direct action such as Inman's attempting to sue the employer, or in this case the third-party action of Howe and Heiner, if that underlying claim is as a result of an injury arising out of in the course of employment, it's precluded. And as to contribution, because we cannot have joint liability, the Inmans could not sue us directly for those injuries. Therefore, Chapter 668.5 regarding contribution prohibits the cause of action brought by Howe and Heiner.
All right, thank you, counsel. Mr. Weston?
Your Honor, may it please the court and counsel who are present today, I'm going to try to shoot with a rifle, but the court might determine it to be a shotgun blast, so I will see how I do. Howe's argument is very, very simple. It's simple because in 2007, the Iowa legislature codified a claim where the parents of an adult child could bring claims for the cause of their wrongful death, and that's Iowa Code Section 613.15a. And so since that time, no court has decided a case to determine whether or not that kind of claim that Ms. Pickens and Mr. Inman fall within the 8520 exclusive remedy provision or Chapter 85 in general. And so this court needs to look at Chapter 85 and the words expressed by the legislature and the people of Iowa when Chapter 85 was codified to determine whether or not the claims of these two individuals come within the workers' compensation framework. Section 8520 is typically referred to as the exclusive remedy section of Chapter 85, but its language is very, very important because it says that the rights and remedies provided by this chapter are exclusive. And then the scheme of the chapter is to, in effect, prescribe, list all manner of situations where an employee is injured, where an employee is killed, and sets forth, claimant by claimant, the people who can recover and what they can recover. So that's prescribed. It's listed. Chapter 85.31 is a section that deals with the claims made on account of the death of an employee. And there is no provision for the recovery of any workers' compensation benefits for people like Inman and Pickens.
And they're not treated as beneficiaries under the
They are
statute.
not treated as beneficiaries under the statute. And therefore, the court asked a policy question. Didn't Hanifin make a concession by agreeing to participate and do business in a state like Iowa that has a workers' compensation scheme? Did it make a bargain to say, we will participate in this scheme and do business in the state of Iowa, and we will do what is necessary to protect our employees against the risk of injury when they are on a work site or working within the scope of their employment. In turn, we get certain immunity. And our response to that is they made no such deal with the two claimants in this case because they are not part of the workers' compensation scheme. Because of that, there is no remedy or right that is expressed for them, and therefore there is no bar for them to bring suits if they would have chosen to against Hanifin. Because they are allowed to bring a suit against Hanifin, there can be common liability under Iowa Code Chapter 668, Section 5, and we can seek contribution from Hanifin for their loss. Now, in its argument, Hanifin has raised several issues. At one point, it asked the court to assume that the legislature intended to bar claims such as Inman and Pickens. That's not expressed in the statute, therefore I'm not sure what the court can do with that. Hanifin cited the unpublished decision of the Iowa Court of Appeals, again, a case that does not involve claims made by adults on account of the death of an adult child. And when the court reads the Brem case, which is attached to the reply, I think the court will determine that Brem actually can be read and should be construed in a way that supports our argument. And if the court looks, for example, on page 3 of the decision, on the second column, because it's unpublished, there's not a West site for page number. The court says, the question then is whether the estate's claim falls outside the fundamental coverage provisions of the Workers' Compensation Act, or whether the injury itself is in itself covered, but under the facts of this particular case, the compensation is inadequate. And the court decides this case on the basis that the claims were that people who were compensated, the Brem plaintiffs, all are within the compensation scheme of Chapter 85, that they were undercompensated because the decedent had 2 full-time jobs at the time of his death and was not able to recover any additional benefits from that second job. And so when the court reads Brem, and the court reads all of the authority cited by Hanifin in its resistance to the motion, there's not a single time where this kind of claim has been found to be inside or outside of the workers' compensation system, and we think just the plain reading of the statute demonstrates that it's outside of the workers' compensation system because these two individuals cannot recover under it. The court handed us before the hearing this afternoon a case from Massachusetts decided in 1992 called St. Germain versus Pendergast. That case has decisions that have to do with independent contractor, which quite frankly I didn't have time to look at, but I did look at the workers' compensation questions there. And importantly, the workers' compensation scheme in Massachusetts is different than the workers' compensation scheme in Iowa. Apparently, under the workers' compensation scheme in Massachusetts, and I'm trying to read it, I think that statute says that if the parents of an adult child is depended upon that child in whole or in part, then they are barred from recovery under the Massachusetts Workers' Compensation Scheme. The Iowa statute is different. Iowa does not have a corollary that says in whole or in part. In fact, the only adult consortium, or the only adult who can recover under 85.31 of the Iowa Code, and I think it is subsection It's in 85.31. I'm trying to find it real quickly. It has to be, it's 85.31(1)(a). When death results from the injury, the employer shall pay the dependents who were wholly dependent on the earnings. There's no allegation made by Inman or Pickens that they were wholly dependent upon the late Jesse Inman for their financial wherewithal and support. And therefore, we think that the St. Germain case is distinguishable because apparently in the Massachusetts scheme, in the St. Germain case, the claimants were within the ambit of the workers' compensation system and they would not be in Iowa. So in conclusion, Your Honor, these two claimants who have brought suit against Howe and against Langhoff are not covered by Iowa Code Chapter 85. They get no compensation there. Therefore, the 85.20 bar does not cover them. They could have, if they would have chosen, filed suit in common law against Hannafin, and because they could, we think now our clients can seek contribution against them, and we would ask that the motion to dismiss be overruled. Thank you, Your Honor.
Is there any material difference in arguing the Heiner case?
I don't believe so, Your Honor. I believe the issues are the same.
I'm wondering if we can just proceed for a responsive argument at this point.
Sure, Your Honor. I mean, I don't really have anything more to add. I mean, so I don't think there's any material difference.
All right, then we're back to rebuttal.
Thank you, Your Honor. I think, first off, Mr. Weston's incorrect in that the Inman plaintiffs could bring a direct action against Hannafin Company as a matter of law. The fact is that they would be barred just like Howe is barred, just like Heiner is barred. Mr. Weston touched briefly on the Brem case. There were two issues in the Brem case. The first one was the compensation issue from a second job, and that's what he talked about. But the second issue in the Brem case was the adult children's attempt to bring a common law action for wrongful death against a Dubuque Community School District, which, just like the parents in the Inman case, are not people who are compensated or generally thought to be able to recover under workers' compensation. And the Court of Appeals, Judge Tabor, clearly ruled that because the injury arose out of and in the course of employment, the common law claim by the adult children against the employer were barred. And I understand the appeal, and Mr. Weston argues it eloquently, that if you look at the damages, which potentially could be recovered by the Inmans, those are damages which are not compensated for. But it's the same thing with children when the mother recovers when the husband is killed. The children don't get consortium damages. It's any of those types of damage claims. And again, I think Larson, as adopted by the Iowa Supreme Court, makes it clear if the injury itself comes within the coverage formula and action for damages is barred, even though the particular elements of damage is not compensated for. And that's what we have in this case. From Hannafin Company's standpoint, this tragic accident was something they did not bargain for. but it's clearly something which is covered by the Iowa Workers' Compensation Act, and as an employer in the state of Iowa, they are entitled to the immunities by 8520. And in essence, no court in the state has subject matter jurisdiction over that claim by virtue of 8520. Original jurisdiction is with the Iowa Industrial Commissioner. Thank you.
All right, thank you, counsel. Is there anything else we need to address today, folks?
No, Your Honor. Thank
No,
you for
Your
your
Honor.
time.
All right,
Thank you.
we'll get something out as soon as we can. It's an interesting issue and obviously a very compelling case on many levels. So we'll get something out as quickly as we can, and be careful on the way home.
Thank you very
Thank
much,
you.
Your Honor.
Thank you.
All rise.
You know the spellings, Terry?
I do.
Okay.